Thank you. Thank you, Eric, for your introduction and for recalling so many times the bomb crater effect. I will not speak about this today. This is an experimental work and has been done together with Johannes Buchenmeier and Eugene Dimant. They were PhD students when we ran this experiment, and now they are working at the University of Cologne and at the University of Pennsylvania. It's an experimental research, so it's an experiment. I can skip this because you know better than me these kind of things. And I go directly to the psychological, issues that we tried to explore with this experiment that I will present you today. I am an economist, and from the economic point of view, to evade the taxes accordingly with the standard theoretical framework that we use in analyzing tax behavior is just a matter of expected utility maximization. This was exactly what Allegan and Sadmo did in their model in 1972, and till now the, let's say, standard theoretical benchmark for economists is still the same. But we also know that this frame is not enough to understand the real drivers of taxpayers' behavior. So a huge amount of the studies has been done across time to investigate about the psychological mechanisms that influence the behavior. And among the others, there is one which is quite fashionable nowadays, at least among behavioral economists and economic psychologists, which is the so-called whistleblowing mechanism. The whistleblowing mechanism is a way that allows to a taxpayer to denounce someone else who is in some way involved in tax evasion. Here there is a sentence by the legal dictionary about one of the possible phases that whistleblowing can take, and it's the case when the state encourages whistleblowing by giving something back to the whistleblower. For a person accused of a crime to decide to give the prosecutor evidence about the crime, including facts about other participants in the crime, in return for lenient treatment, a plea bargain, and or a recommendation of a light sentence. So it's a situation where the state encourages whistleblowing. And we have two main kinds of whistleblowing. One is taxpayer versus taxpayer, is the situation when a taxpayer denounces another taxpayer who is evading. So I know that someone else is evading and I denounce him or her. Which are the motivations? Well, psychologically speaking, we can have moral, ethical, psychological motivations. For example, we can be moved by social norms or by personal ethical values. Envy, which is very human, a very human sentiment, and also the pleasure to punish. This has been studied using fMRI machine. I cannot go into this detail, but it's a very interesting issue. And of course, there is also the situation where, as I told you, the tax authority encourages whistleblowing. Then there is another situation of whistleblowing, which is the taxpayer versus tax officer. Tax officer in this case is a corrupted tax officer. So it's the case when a taxpayer decided to denounce a tax officer who is a corrupted one. And about this second kind of whistleblowing, there is less evidence. From the scientific point of view, has done almost nothing to explore this issue. And here the psychological mechanisms are not so sharp as in the first case. At least the first case has already been studied a bit, but the second one is not explored till now, at least as far as I know. What we did in our experiment was to see what happens when we introduce an institutional change into the frame of the experiment. By the way, an experiment is perceived, the experimental design is perceived by the participants like an institution. The rules of the game that we impose to our participants are perceived psychologically like institutions, laws, rules. And therefore, a change in the experimental design is equivalent to a change in the institutional setting. So what we did was to provide legal immunity to bribe giver for blowing the whistle as a measure to deter tax evasion. And the idea is, well, I can skip this because we don't have enough time. Yes. Okay, so we investigate about the so-called principal witness regulation, which is a law that allows to implement the mechanism of enforcing whistleblowing by the authority. And the scheme in our game is very simple, as you will see. We have two main kind of agents in our experiment. One agent is the taxpayer. The other agent is the public officer. So imagine a situation where a tax officer has to apply the law to get the money from the taxpayer. This is the situation, the frame. And the taxpayer can only evade if the public officer accepts a bribe, accepts to be corrupted by the taxpayer. Is it clear, the scheme? Very, very simple. We ran different treatments to test if introducing a law that encouraged the taxpayers felt evading to denounce the tax officer, to encourage this, has an impact on taxpayers' behavior and on public officers' behavior. Okay? So this is the general scheme. Quite simple. We ran many treatments, more precisely we ran 4 treatments. The first one is the standard treatment, and it works in the way I told you. There is a participant to the experiment that plays the role of a taxpayer. He receives money, real money. We pay our participants with real money. And he plays 20 rounds. He has to decide to pay or to evade the taxes expected across these 20 rounds. And to do this, he has to convince another participant to the experiment who plays the role of the tax officer or the public officer to be corrupted. So he sends a bribe to the tax officer. If he or she accepts, he can evade the taxes and the other one gets the bribe. Okay? Good. So this is the standard treatment. Then we have a second treatment, which is a treatment where they play the game exactly the way I told you for the first 10 rounds. But at the 10th round, we introduce a change. We tell to the taxpayers that if they denounce the public officer, if they are found evaders, of course, and they denounce the tax officer, the public officer, they can receive a discount on the fine that they have to pay. Okay? And the tax officer is punished instead of them. Mm-hmm. So the first 10 rounds is without this. The second 10 round is with this new regulation. Then we have a third treatment where there is always this rule at work. So from the beginning there is this law at work. And finally the other one, the fourth one, where we inverted the time. So we start with the law, with the law that I told you, and then we take it off for the second set of 10 rounds. Why we did this? Because we want to see if the institutional story, let's say history, the institutional history does matter in influencing behavior, okay? The taxpayer's behavior. So this is the game. This is the extended game. I don't know if I needed to get into this in detail because I already told you how it works. So if you want, I can do it. It's because we always need theoretical predictions when we run an experiment. So this is the standard game theoretical prediction, which I can summarize. I can summarize here. No, it does not accept to do it. Okay, so the game theory prediction are the following. Given the parameters that we include, by the way, I show you the parameters at least, very, very quickly. What they had to declare each round was 80 EQ, which is experimental currency unit. It's always the same trick. It's a way to give more money, virtual money, to the participants. Then at the end of the experiment, this money is transformed in, this virtual money is transformed in real money. Okay, so 80. Then there is the bribe that they can offer, which is a maximum of 30. The probability to be audited is 20%, which is very high, but I could tell you about this, and no, I don't have enough time. Anyway, it's 20%. The tax rate is 50%. It has been parameterized on the Italian standards because Italy, as you probably know, has a very high fiscal pressure, so 50% is something that Italians find fair. You can trust me or not, but it is. Well, anyway. The fine rate is the 25% of the amount evaded, and finally, the commission that I forgot to tell you that the public officer get money from the tax collected, so he has an advantage in collecting taxes, which is the 15% of the tax collected. And okay, so this is enough. I can go on. Given these parameters, the game theoretical predictions that I show you using the picture that I showed you is that the unique subgame perfect equilibrium of the bribery game, which is the game that you saw, in this situation, the taxpayer should declare 0 taxes and offer a bribe of exactly 6. Okay, so this is the optimal rational choice for the taxpayer, which in equilibrium is always accepted by the tax officer. So we have a normative theoretical prediction about this game. Similarly, in the EG means extended game, is the game where there is the law at work. Taxpayers declare 0 taxes, but the bribe offered in the unique subgame perfect equilibrium outcome is a 10, so increase. This is very intuitive. If I am the tax officer and I know that the other one, the taxpayer, can denounce me, I raise my bribe. I want more to be corrupted because I'm running the risk to be punished. So the prediction is perfectly intuitive and it works in an intuitive way. If all the participants are rational, in particular if the public officers are rational, they should reject any bribe lower than 10, okay? If they are rational. So here are the... I skip this because it takes too much time. It is interesting, to be honest, but with you, but I skip it because I have only 15 minutes, Professor Kirchler told me. Only 3 minutes I have. So, thank you, and I'll see you later at the coffee break to tell you the end of the story. Okay. Okay, I skip this because it's too long. It's the experimental procedures description, and I go to the results. I skip also this, and I skip this, and this is a table I understood from Christoph that you don't like tables, so I skip the table as well, and I go directly to a qualitative result of the results. So, first result. The level of tax compliance are significantly higher with the rules, this law that we introduced in the experiment, the principal witness rule. Effect is mainly driven by female participants. By the way, I will spend a bit of time on this because it's the most interesting result of the experiment. 2 minutes more. Okay. It's about the gender effect, something unexpected. By the way, the unexpected results are the interesting of experimental economics. I like a lot when I find something that I was not expecting from my boring theory, and I get very excited when I find this. On the other side, the behavior of males are almost unaffected by the law. So to have this law on board or don't have it does not matter for males. While it is very important, this change for what it regards females. The bribe acceptance threshold is, as the theoretical prediction said, significantly higher with the regulation. And this was, as I told you, very intuitive, because as I told you, if I run the risk to be denounced, I want more to be corrupted. And here I have the graphs that Christoph liked, and I show you. I don't remember they work exactly, but I will try to tell you the story. So the first set of graphs, the first two, is the percentage of taxes paid by the participants to my experiment in treatment 1, in which there was no principal witness regulation, so there was no law working. While the second graph is a treatment 2 with principal witness regulation. As you can see immediately, it's very clear, there is a shift of the tax declaration up. So the introduction of this law increases the tax compliance in a significant way, okay? Trends in average incomes declared without PVR, which is the graph top left, the solid line, and with the PVR, graph top right, solid line, as well as average taxes paid without PVR, and with PVR across treatments. This is the description of the graphs. So everything goes up, the income declared and the amount of taxes paid, okay, with the principal witness regulation. Then let's see what happens for what it regards the bribe acceptance. In treatment 1, where there was no principal witness regulation, bribes were quite high in terms of acceptance, of percentage of acceptance, but they remain quite high also in the treatment 2. So this is not so expected, in the sense that we thought that bribes should be rejected more when the principal witness regulation is at work, but it is not the case, okay? So the percentage of acceptance does not change. The public officers are not particularly sensitive in terms of acceptance of the bribes to the introduction of the law. What changes is the behavior of taxpayers, but not of the public officers. And here there is the result I told you about females and males. The first graph shows the percentage of tax declared for what it regards female in the treatment where there is no law, there is no the law, and in the treatment where the law is at work. Where the law is at work, women pay much more taxes, declare much more taxes, than in the case where the law is not working. While for what it regards males, this does not matter. They are completely neutral for what it regards the introduction of this law. And so is females that justify this shift upwards of the declaration. It's only females that are driving the phenomenon. But this is not the counterintuitive phenomenon. I will come in a while. I skip this, and I go directly to the treatment where so remember, treatment 1 and 2 we have the principal witness regulation, or we don't have it, okay? For the whole experiment. In treatment 3 and 4, we introduce it at the middle of the experiment. So we have an institutional change, a switch in the institutional setting. So this is what happens when we introduce with institutional change. For what it regards the amount, the percentage of taxes given, as you can see, there are strong differences for what it regards the case when you introduce the principal witness regulation at the round 10. Why? Because as you can see, there is a change into the slope of the percentage of taxes declared. Yes, I skip this. This is faster, and I go to this one. Oh, this is the most interesting result. Do you remember that I told you that females do pay more taxes when the principal witness regulation is at work from the beginning of the experiment, if compared with the case where there is not? Okay? Do you remember this? Now, what happens if this law is introduced during the experiment, not from the very beginning? It happens something absolutely unexpected. Once the law is introduced, and it's this graph, this one, okay? These are males, these are females. No principal witness regulation, then introduction of the principal witness regulation. So it's the same group of people experiences these two situations during the same experiment, okay? Females were complying with the law, meaning paying taxes. Once the principal witness regulation is introduced, they start to evade. Yes, massively. While males are not affected. What's more, they don't care. It's something that they don't care. This is something really new, because we know from the literature, and Eric can confirm, I think, that females are more honest than males in this kind of experiment. Females almost always are tax compliant, while males like to evade the taxes, at least from our evidences. But this is something new. Why? Why, if I introduce the principal witness regulation, females start to evade? Why? I can answer to my question. Okay, good. And then I close. I don't know. This is the answer.
Okay. Indeed, Luigi always has interesting results, especially those which he does not show. Well, you heard now two experiments, and it's not always easy to understand these experimental approaches, especially if you're coming from another discipline than psychology or behavioral economics. And you might think differently about these game theoretical approaches and lab experiments, where we usually have students as participants, and the whole setting is quite artificial. But believe me, the experimental approach is really important to test hypotheses sharply and to develop our theory. Of course, it's not the end of the whole story. We need to go out in the world, in the field, and see whether what we are doing and finding is really valid. Well, now Rupert Sausgruber, who is a professor of economics at this university here, at the Vienna Economics University, will talk about experimental approaches, but not about single experiments, research in economics, and summarize this research. He will talk about penalties and general anti-avoidance rules and what we have learned so far from the behavioral economics approach. Rupert, the floor is yours.
Okay, thank you. So when I prepared this talk, I was reading what was written on this slide, and it said the panel will explore current research on the use of penalties and general anti-avoidance rules from the perspective of economic theory. So I saw them going back to our approaches, and I'm giving you an overview of what economics says about these issues. Okay, so the starting point is that the state needs money to run business, basically to provide worthy government expenditures. And once you introduce taxes to do that, you have basically 3 ways to increase taxes. The first is you increase enforcement, you raise the tax rates, or you broaden the tax base. And optimal tax policy would account for the cost of increased enforcement. So it's basically an option that you have, but it's a costly option, right? So what are the costs? You have administrative costs, the costs that are actually showing up at the budgets of the tax administration. You have compliance costs, the cost that doesn't show up in the budget, but are of course part of the cost of taxpayers. There's excess burden, basically taxpayers reacting to being taxed, so they move business abroad, they consume less, they produce less, things like that. And there's taxpayer uncertainty. So this is basically it's a reduction of utility, because you have a threat of being fined and audited, which is a reduction in utility terms. So people have a preference to pay to get rid of this uncertainty. So all this tells you that the optimal tax gap is not 0, right? So I'm trying to make to tell you that there's a trade-off when you increase enforcement. There's a trade-off in terms of cost. Okay. So there are good reasons to crack down non-compliance. First of all, non-compliance leads to an unfair distribution of the tax burden, which is obvious for individual taxpayers. It's not so obvious if you talk about corporate tax evasion, because corporations are run by individuals, and it's not clear why you treat corporate entities in terms of fairness. So it's an elusive concept here. It's especially elusive. So there's this quote by the Mirrlees Review. It's not meaningful to think about the effects of taxes on companies separately from the effects of those taxes on individuals associated with companies. So it's just a difficult issue here. The second issue is that non-compliance is costly to the society. Basically, when you narrow the tax gap, if you manage to narrow the tax gap, you actually free up money that you can use to invest in worthy government projects, or you can cut existing tax rates, or you get rid of excess burden. But there's also another issue, which is probably not so prevalent. Basically, if all these people and all these companies spend a lot of money to find ways to get rid of their tax burden, we would call this like rent-seeking, right? It's a huge expenditure taken by companies, taken by individuals, and it's essentially wasteful expenditure. In the sense that you could use all these resources alternatively, you could use those alternatives in a more productive way. Of course, you see tax administrators and tax people are employed by all these issues, but in a sense it's wasteful, because you could use it in an alternative, much better way. Okay, so how can you increase tax compliance? The economic approach, as Luigi already pointed out, is the standard Ellingham-Sandmo model. It's basically an extension of this Becker economic model of crime. And the 2 most important variables in these models are the probability of audit, P, and the fine in case of detection. And even though it's a very simple model, it has already some interesting implications. One interesting implication is what has been referred to as hang them with probability 0. and the main intuition is that increasing the probability of an audit is quite costly because the tax administration needs to hire auditors, and it's very costly to do it, whereas increasing fines is relatively cheap. So this implies that the optimal deterrence strategy would be one where the probability is rather low and the fine is really, really high. Okay? There are, of course, reasons why you can't increase F extensively, and these are mostly legal issues, fairness issues. You cannot increase punishment over proportionally to the perceived seriousness of a crime. So tax evasion is typically perceived as a rather modest crime in many countries, not only in Italy.
It is a crime,
It's a crime. It's a crime, but it's a modest one. And typically the punishment with regard to that is not so excessive. Okay. There's others. So there is the probability of detection typically is determined by the revenue services, whereas the fines are set by the judiciaries. Okay. So I'm coming now to evidence. So what does the literature tell you about evidence? And even though it's a very simple model, there is extensive evidence that supports the model. So whenever you increase the audit probabilities, you find higher compliance. You find that people who have been audited are more likely to comply. When you increase information about the audit rates, you have more compliance. And if you look at the details of the studies we have been presented now, you also will realize that whenever the probability of an audit has been increased, you see more compliance. I think it's a real established fact that higher enforcement probability leads to more compliance. The evidence is not so clear regarding penalty size. One reason is that it's not easy in the field to vary the size of penalties. So when I'm saying here compelling empirical evidence, what I mean is, do we have causal empirical evidence? And it's very difficult to implement a change in penalty size in the field such that we can causally argue that the penalty size increases audit rate, compliance rates. There's some evidence from lab experiments which kind of points to the direction that an increase in penalties is less effective than an increase in audit rates. There's some evidence on shaming. Basically, if you publicly announce people who have evaded taxes, then this has a big effect. So there's evidence that penalty rates point into the same direction than audit rates, but it's less compelling, basically. Okay, so the literature has proposed several extensions to the simple model, which are basically to account for non-standard preferences like tax morale and honesty, some extensions regarding what determines the probability of detection, and also an extension how to account for tax avoidance. Okay, tax morale. So the issue is basically that this early literature argued that this probability of detection in reality is really low. And the way they did this, basically, they looked at the base was all the taxpayers in the country, and that they counted the number of audits the tax authorities conducted. And they concluded that the probability of an audit is really small. Nevertheless, we see a lot of tax compliance. And they concluded there must be something explaining this, which is tax morale. But in essence, if we play around in the field with tax morale, we find very, very little evidence of that. I'm trying to explain what I mean by that. So there's loads of empirical studies working with moral appeals, basically sending people letters, well, be an honest taxpayer, it's your moral duty to pay taxes and things like that. And there's virtually no evidence that these appeals work. So I've cited several studies here, and with a very few exceptions, these studies find only weak effects. Okay? I also have an issue with corporate tax morale. So corporations are typically run by executive committees, and these committee decisions are kind of different than individual decisions. So I'm a big believer in honesty. I think people are generally honest. But if it comes to committees, I'm very skeptical. One reason is simple aggregation. We know that many people are not honest, and you have a committee decision. Typically, the median preference is the one who is decisive. And so if you have a majority of dishonest people, the group decision will be dishonest as well. There's also a coordination issue, sometimes in this corporate decision-making. Being dishonest as a group pays off more, right? So everyone has to be dishonest, so the stakes are higher. And finally, there's behavior in competitive environments. So competition basically forces you to be dishonest, because if you're not dishonest yourself, someone else is going to be, and then you're out of the market. Okay, so there's a very strong competitive force that drives you down to unethical behavior.
3 minutes. 3.
3 minutes, okay. Legitimacy, I'm a believer in legitimacy. I think there's also research supporting legitimacy. Basically, it's different from honesty, but it says that taxpayers take care, they have a preference for being treated in a fair and, in a fair way. Okay, what's determining the probability of detection? So, as I said, this earlier literature thought that tax morale is really important, but this recent literature basically tells us, so this study by Kleven from Denmark, it was a field study randomly auditing a huge amount of taxpayers, and the main variable of interest was whether the income is third-party reported or self-reported. Okay? And the main result is the tax gap is really low in Denmark, but it is low because most income is third-party reported. Okay, there's absolutely no way that you can cheat on your tax unless you're self-employed, and the people who are self-employed, they cheat extensively, even in Denmark. Okay, so the conclusion is the Danes are unable to cheat, they're not unwilling to cheat. So it's another evidence, a piece of evidence, that tax morale is not the driving force, it's really the information of the tax authorities they have and to pin down tax enforcement. Avoidance, basically, the way economists model avoidance is an extension of the Ellingham-Sandham model. It's basically, they argue that any act of avoidance is costly, okay? So it's avoidance enters as cost of finding avoidance opportunities. And of course, then the probability of detection and the fines become less effective because people can substitute and enter avoidance. And so from this perspective, a general anti-avoidance rule would, of course, increase enforcement. Okay. We do have a lack of evidence on very important questions. So the first one is, if we increase measures to deter evasion, to what extent will taxpayers respond by increasing avoidance behavior? We don't know that. Okay, it's likely that this happens, but it's difficult to quantify it. Again, if policy introduces a GAR, how will taxpayers respond? Will they increase tax evasion again, or will they engage more in reasonable tax planning? It's very difficult to get empirical information on these kind of questions. Okay, so if we increase or introduce GARs, what is actually quite likely to happen, I think, is that we observe a strong reaction towards what we call legal avoidance, basically relocation of real activities or general equilibrium effect. So basically people will lay off domestic workers, they will try to produce abroad. So these are true costs if you introduce those GARs, but they will of course be effective, so there will be less tax evasion. Okay, I'm summarizing. Non-compliance is a problem also from an economic perspective, but zero tax gap is not optimal. From my perspective, there is little evidence that promoting tax morale would work. I do, however, think that procedural fairness is important to sustain legitimacy. The standard model, the standard economic model, works quite well, and it's easily extendable towards GARs. So enforcement in terms of GARs reduces tax evasion, and also increased transparency works, because increased transparency means that the probability of detection is increased, so you have the standard deterrence model coming into life. However, enforcement is likely to increase avoidance, and GARs is likely to increase reasonable tax planning. And there are some side effects of GARs and legal enforcement. There may be indirect effects via strengthening reputational pressure, which is again basically like increasing the probability of detection, and it may also enforce social norms. Okay, thank you very much.
Yeah, thank you, Rupert, for your insights. I don't believe them. You need more psychology at this university, I think. Now we come to Christoph Werzsäcker's talk. He's a lawyer and he's in the field. So we will learn a lot from your experience as a senior counsel in the Financial and Fiscal Law Unit of the International Monetary Fund in Washington. And Christoph, you have in your CV also mentioned many lectureships and seminars which you took at different universities all around the world. You were a tax consultant in the World Bank, so we expect to learn a lot about the experiences in the field when you talk about tax compliance, tax law drafting, and the anti-avoidance rules.
Okay, thank you very much for this very kind introduction. Of course, I also have to thank Nina for inviting me to this conference, who actually managed to find a few lawyers that are working at the fund, so the fund is not an entirely institution made up of economists. So a lot has already been said, but I wanted to start briefly by saying a few things of what the fund does, because it also shows what we don't do. So the IMF is an organization which has actually a relatively specific mandate, which is focused on what we call global financial stability. And so we are given specific powers under the Articles of Agreement of the IMF, which is the charter that set up the fund in 1945, which set out the things that we can do to achieve that global financial stability. And tax is relevant for all those three functions. So I've summarized them here. I'll go quickly because I want to come to the GAR in a minute. But those three things that you can find in the Articles of Agreement are TA, or technical assistance advice. It's probably the most obvious area where tax is important in our work, where we provide assistance to member countries. The previous slides that we had 189 member countries. Nauru, if you know where that is the most recent member of the IMF. We do roughly 200 HQ-led missions on tax per year. As far as the work of the legal department where I am from is concerned, we provide legal drafting assistance to member countries. Looking back over the years, I've tried to work out with roughly between 200 and 300 tax laws on the statute books anywhere in the world we've contributed to in some shape or form. Probably the most high-profile thing that the fund does is the lending activity. These are the programs that you will hear about in the media, and perhaps some of your countries have been experiencing them. Tax obviously is often a core element of those programs, so the financing arrangement that the fund enters into is technically a swap arrangement where we swap local currency against typically US dollar, but any of the currencies in the SDR basket. But what's relevant here is that typically we don't perceive this as a contract with a country, but an engagement of the country to carry out economic reforms, to get back on a fiscally sustainable path. And obviously tax is an important part of that exercise. And so in the context of lending arrangements, we typically have what we call structural benchmarks. This is the famous conditionality that you might have heard of in the media, where countries agree to tax reforms specifically. And actually looking back over the past couple of years in the post-global financial crisis period, when we scrutinized our own programs, we've seen that actually the number of conditionalities put in the tax area have actually increased. So it is becoming also more important in that part of our work. Surveillance is a third area of work. This is a famous Article 4 discussions we have every year, typically every year with our member countries. So when you become a member of the fund, you commit to surveillance, and so typically every year you get a visit from not me, but my colleagues in the area departments who have a sort of a health check of the country. And tax, certainly in the past couple of years, has played a more important role in some of those discussions where tax is a structurally important issue, and you can work out which countries that are for which that is the case. I was also going to talk about some new tax initiatives, the global tax agenda, but I will skip this to proceed and allow time for discussion at the end. I will also skip this because Rupert already covered this. This is some graphs from a recent board paper we did on tax compliance and tax administration challenges. This is just to show how, this is showing VAT gaps, or tax gaps, several tax gaps. It's not just VAT, also CIT in a selected number of countries where before the crisis, compliance gaps were generally declining. In the post-crisis, immediately after the crisis, there was actually a big increase in tax gaps. And so to some extent, non-compliance was sort of an automatic stabilizer, as economists would say. Obviously not a very efficient one, but just to show that compliance and non-compliance has become more of an issue in the post-crisis period. Of course, what's relevant is unpacking non-compliance, unpacking tax gaps, and a lot has been said about that already, and I won't repeat that here. What I want to focus on perhaps more is what is the relevance of legal frameworks, because that's where the lawyers come in. And yesterday there was some discussion on was complexity of legislation, complexity of the taxes, and generally I presume that's also complexity of legislation. How does that impact compliance? And so there's not a lot of evidence on that, other than from our own experience in working with countries. And of course, from my own personal experience, I can tell you this is actually very important. And it's also become part of a recent stream of work that we've worked on with our colleagues from the OECD, where we produced a report for the G20 that will be presented actually in a couple of days' time at the Baden-Baden Summit of Finance Ministers on tax certainty. And so in the context of that exercise, the OECD ran a couple of surveys, a business survey and a tax administration survey. And one of the questions that was asked in that survey was specifically on complexity of legal frameworks. Unfortunately, because the report, this is an issue of timing here, the report has not been presented formally, I cannot talk too much about it. So I would say stay tuned. It will be presented at the end of this week and probably be released for comments later this month. But you will find in there, in that report, some discussion, some new evidence on the relevancy of complexity of legal frameworks, both from the perspective of business and tax administrations, and also some discussion on what are the approaches towards improving or reducing complexity. There was some discussion yesterday about maybe the pitfalls of plain drafting, which I think we agree with. I think we come out on more what we call principle-based drafting, and I think that is also relevant for the discussion on GAR, so that's why I wanted to mention it now. And I'll come back to it in a minute. There's also some discussion on anti-avoidance rules. Again, we'll have to wait until the report comes out. I'm really sorry about that. But I can tell you about this publication, which we released last year, which is a note, sort of our own sort of little toolkit. Toolkit is the new buzzword in international tax. So this is a relatively short publication that you can find on our website. It's a new series that we launched in the legal department called Tax Law Technical Notes on a topical issue, and this one is specifically on GARs. So the way we approach this note is in a very practical way. It has some general observations on designing and implementing a GAR, and then has sort of a sample set of provisions, not tailored to any jurisdiction in particular, but sort of a generic legal provision with a sort of explanatory note on how it is supposed to apply, and then with a numbered example how it can take effect. So the primary focus of this note was, I would say, domestic GAR provisions. But I think I should say a few words also of how it has gained more importance also in the international tax agenda. So yesterday there was obvious reference to the OECD BEPS project. So as you probably all know, in the context of Action 6, combating treaty abuse, which will culminate in the signature of the MLI, the Convention to amend as many bilateral tax treaties as possible of those countries that sign on to the MLI, and we'll have to wait and see how many those are. But one of the commitments when you do sign on to the MLI is to introduce either a principal purpose test, which is effectively a treaty-based GAR, or a limitation on benefits clause. Now, again, we're a bit early in the game. There was a speed dating exercise a couple of weeks ago at the OECD where countries that are planning to sign on to the GAR had sort of one-on-ones with treaty partners to see where their positions are, because countries can reserve and opt under the MLI, and this is one of the options, principal purpose test, or LOB. Now, the countries that have made public statements to the effect of what they will do, it seems like most countries will opt for the principal purpose test, not the LOB, which is sort of ironic, because my understanding was that the LOB was put in there for purposes of the United States, which typically uses LOBs, but of course the United States is not going to sign the MLI in the first place, so it's sort of ironic. But anyway, so that's sort of at the international level. At the domestic law level, I think there's also some interesting developments here. So many countries have these sort of domestic law GARs that are primarily focused on general tax avoidance issues. But more recently, a number of countries have started using these type of provisions to specifically target international tax avoidance. And so I'm obviously referring here to the diverted profit tax in the UK, which is formally not a GAR. It's a standalone tax, but it obviously smells like an anti-avoidance rule. And other countries have taken suit in that respect, and Australia is one that has already put out legislation to that effect, and Ali will know the situation very well, but I think very recently New Zealand has announced that it will actually move in the same direction. And so the Australian-New Zealand approach is slightly different in that, unlike the UK approach, which is sort of the standalone tax, the Australian-New Zealand approach is sort of to bring it under the anti-avoidance rule as sort of part of the corporate income tax infrastructure. And so and the reason why I think that's sort of an interesting development is that technically what the GAR is supposed to do is not patch up underlying policy problems. It's basically to reestablish the intent of the legislator. So it's a substance over form provision. But in these sort of internationally targeted rules, it's almost as if you're using this kind of rule to actually cure an underlying problem of deficiencies in the international tax system, which are not fundamentally solved by the BEPS project. So that's sort of, I think, an interesting development. And I'll come back to those two examples as well, because they're relevant also for the penalty aspect of it. So I was also going to say what a GAR is. I think most people know. So as I said, it's a substance over form provision. What is critical, I think, here is that, and that's relevant for the next slide, which is it is potentially quite a powerful tool in the hands of the tax administration, because it's meant to give the tax administration the power to overrule or sort of to discard transactions entered into by the taxpayer that are, other than for the GAR itself, are legally sound, are sort of in line with the letter of the law, but not the spirit. And so you're asking the tax administration to also sort of second guess, in a way, the intent of the legislator, which, of course, may not always be very clear, certainly in the context of complex tax legislation. And this is where I want to come back to the point of principle-based drafting, where if you adopt that style of drafting approach, where you have a principle provision that sets out the overall policy intent, that will make it easier for, in light of the application of a GAR, to find the policy intent of a more complex provision introducing that policy. So of course it's not meant to reestablish what is fair or just. It's still a legal provision. It's not some kind of moral obligation. But nevertheless, it is quite potentially a quite powerful tool. Okay, so that's why the note also makes clear that institutional capacity is very important in this context. And most of the discussion, I think also most of the experiments here are run in sort of OECD-style sort of countries or more developed countries. But in developing countries, this is obviously often a very big constraint. But that's not to say that most of the countries we work with, when they are developing countries, they're also very interested in GARs, and they also want to know about them and want to use them. But obviously, when providing taxpayer protection is sometimes more of a constraint in those kind of countries. So this is just a general point made here that procedural safeguards are important, and different countries go about that differently. So for instance, there's the GAR panel in the UK. I won't go into the details of that, but that's a form of safeguard. The main point being that you need effective dispute resolution systems to back up the use of these provisions. And that's where, and this is something from our own data, we know that many countries struggle with having effective dispute resolution mechanisms. It's already been mentioned yesterday as well. So this is very hard to see, and it doesn't really, numbers don't matter, but the basic point is this. So this is from TADAT, which is it stands for Tax Administration Diagnostic Assessment Tool. That's why we use the acronym. It's meant to be an assessment tool that allows us to diagnose the performance of tax administrations across a number of performance outcome areas, POAs, in a way that make the results comparable across jurisdictions. And so we've done a number of these TADAT assessments. I think we've done almost 40 now, mostly in developing countries, low-income and middle-income countries. And what we find in respect to the performance indicator in terms of dispute settlement procedures is that countries score relatively well in that left axis in terms of having on the statute books an effective dispute resolution mechanism. So they have a graduated, independent system, institutional setting set up. But in terms of the time it takes for reaching a point of decision and for learning from the decisions in terms of administrative processes, many countries score very poorly. Partly there's an issue of data not being available. Countries don't track what is happening. But those that do track often have very lengthy, very inefficient in practice dispute settlement procedures. And so in a context as this, of course, it becomes a bit more critical, the issue of taxpayer protection in the face of a provision that is potentially quite heavy-handed. And so I'll finish on this point, which is I promised I was going to come back to in relation to fines or penalties. So in our note, we do not actually talk about fines and penalties in relation to a GAR specifically. So I think to some extent it's related to the point on effective dispute settlement procedures. You know, if you have a fine on top of the GAR, obviously, especially when there is an advanced payment requirement, the pecuniary impact of that might be quite hard. And so it sort of, if the fine is a proportion of the tax payable, it actually almost doubles the impact of the discretionary power of the tax administration. So if there's no effective remedy, I think we would be quite reluctant to say, okay, when this is your first go at having a GAR, it might be a bit tricky to also impose a fine of 100%. Now, if your objective is clearly deterrence, which is basically what the DPT, the UK DPT, and the Australian MAL, the multinational anti-avoidance law, are intended to do. I think the MAL is 100% fine, Ali. So there the objective is actually basically that you will never have to use it, and that companies will no longer structure their businesses in the way that you find unacceptable, which is the point that Rupert also made. Where the objective is clearly changing behavior, then obviously a heavy fine might actually make sense. I think, I don't know if Philip is here. Philip, the DPT was obviously also meant to change behavior. I don't know how much the DPT has raised in terms of revenue, but probably nothing exactly. So, yeah. So there, you see, it's actually very effective in that way. So in that context, fines do. Absolutely. So absolutely. So I'll stop there. I had a list of sort of conclusions for points for discussion, which maybe we can come back to in the discussion.
Yeah.
Thank you.
We have only a few minutes before the coffee break. Therefore, I would like to ask you for a couple of questions and very short answers. Cesar, yes, please. Microphone here.
Hi. I got a question to Christophe. This kind of analysis of GARs, do you see from a perspective of judges, what kind of role could play the judges in a domestic role? Because as a taxpayer defender, I love the idea of introducing GAR. We don't have it in Mexico. And I think that it can be improved in a lot of the aspects of the relationship. But at the end of the day, the GAR are going to be applied by tax administration. And talking about unacceptable behaviors of the taxpayers, it's dangerous for the taxpayers and of the defenders of taxation. At the end of the day, the tax conflict is going to end in a tax court. How can you link the relationship of the effectiveness of a GAR and the role that can play a domestic judge?
Mm-hmm. Can we collect two more questions and then answer in the panel? Yes, please, Ali.
Hi there. I just wanted to make one remark on the GAR and then a question for Rupert. I think we need to be very careful. If you're too taxpayer rights friendly with GAR, it will lose its effectiveness. And, you know, it's very much evidence-based. For example, with the UK recently introduced GAR, with 2 reasonableness tests, I really do wonder how much success HMRC will have in courts taking cases to court, because, you know, the reason why the Australian GAR and also the MAL are so strengthened is because of, you know, the evidentiary burden on both sides, you know, to prove GAR. But that's just a comment which I'm sure Christophe will pick up on. But I wanted to ask Rupert, because you said kind of like this moral obligation doesn't really work. Because I've actually recommended some of this stuff in my report. And what I've taken it from, you know, in the early 80s, for example, when I moved from the UK to Australia, you know, the drinking culture was there and everybody drunk drive, but there was such a, not everybody, I'm obviously exaggerating for effect, but there was such an education program undertaken that now not only it's a crime, but it's socially irresponsible, and you very rarely see it happen. The other thing was also, another one was about, I forget the ad, but basically keep the country clean. It was such an effective ad done that, you know, the cleanliness of Australian cities, I think, is wonderful as a result. And all of these have been as a result of education campaigns and you know, this moral obligation. You know, and I was wondering whether you had done any research about embedding this moral obligation at a very early stage at schools and also when new migrants come to a country. And I just wondered whether you had done any studies on embedding that moral obligation much earlier in the piece.
Thank you.
My name is Leo Neve. I have a question. I was struck by a remark on the sheet where it says there is a tension between preserving the rule of law and protecting the integrity of the tax system. It's my experience, more or less, that the rule of law is not playing any role in many of these rules of the institutions. Sorry? So, what is, in your opinion, the position of the rule of law in the integrity of the tax system?
Okay, thank you. First of all, will you answer?
Okay. Maybe I'll start with the first question on the role of the judiciary. I think it's a very good question, a very good an important issue. I think I'll try to answer it from a legal design perspective because that's sort of my comfort zone. So in the sample provision that we set out in our publication, we basically have two limbs. There has to be a scheme that a taxpayer enters into, and that scheme has to be entered into for a dominant purpose for a tax benefit. So it must basically be tax-driven. So the sole or main objective or principal objective, you can use different words and they have slightly different meanings, but that's sort of an objective standard. Now, other countries, I think Canada is in that situation, have a requirement that it has to be an abusive arrangement. And that obviously raises an additional bar of a burden of proof, where indeed you get into the situation where judges will have to rule on sort of almost a subjective objective standard. So to the extent that through the drafting of the rule you can keep an objective test, it will help probably also in the application, both taxpayers, tax administration, and judges ultimately. At the same time, I can also say that we also sometimes engage with the judiciary. So when I mentioned technical assistance, we also do workshops for judges but I mean, obviously that's not our primary goal, but I think it is important that judges are also play a role in our part of tax reform efforts so that they understand, what is the objective of this provision, how it is supposed to apply. Because many countries don't have specialized courts, don't have specialized judges, and so when they're confronted with very complex tax cases, let alone these highly technical GAR provisions, you run into that problem. And then the point on rule of law, I sort of almost deliberately not mentioned that issue. I think it's sort of a misconception, really. It's more, I put it more as a typical objection that typically taxpayers try to argue that, well, I've met the formal requirements of the law, and so if you now are going to disregard my transaction based on some implied intent, that is basically violating my legitimate expectations that I was allowed to put trust in the letter of the law. But I guess in the context of purposes in interpretation of tax statutes, the law is not just the letter, very formalistic interpretation. I think as most countries have moved away from that anyway. So I don't think there is a real tension there. It's just an objection that you sometimes hear. So I didn't want to create confusion. That's why I basically just not mentioned it, but I probably shouldn't have put it on the slide in the first place.
Would you like to say something to Ali's remark?
Yes, so I think my point was basically that the empirical literature on tax compliance does not find great support for moral appeals to work. So I looked up especially this literature where they use these moral appeals, and the evidence is very skim. I have to be straight on that. It doesn't mean that social norms are not important. In fact, most of our life is organized by informal social norms, and they work very well. It's just in the context of tax compliance, we have competitive pressures. So it's very costly to comply, basically, and if you don't comply, then of course you face this risk of detection. But if everyone else does, if your competitors do, then it's a strong incentive not to comply yourself. So it's kind of an equilibrium behavior. There's of course this tendency, if you for drunk driving, if you have phenomena that you want to avoid and you back them up with legal provisions as well as with moral appeals, that in combination the whole policy may work. I'm a bit skeptical that moral appeals alone will do the job. That's it.
I'm sure there are many more questions, but the coffee break has already started, and I'm sure the panelists will be ready to talk to you individually and about all the issues. I would like to close by just saying that I think that we are so far looking on a very static situation when we're talking about morale, etc., and deterrence measures. Perhaps we have to look more at the dynamics, at the development of things over time, and we discover that probably there are many phenomena which influence compliance, and we have to look at have a more complex view on the whole issue. I would like to thank you all, especially the panelists. Thanks.